matter?
It is the order under challenge is my maintenance order dated 15th of December 2021. That is under
You are the opposite party. There is a stay order passed. You are ready to argue.
I am ready, my lords, because it's a very brief matter. And I just want to assist my lords on one particular issue, that the order dated 19th April 2023, which is the order for stay, my lords. A sum total of 35 lakhs is due, my lords. This is starting from May 2018, your lordship. That is the order of the learned court below. Until February 2024, that is the amount that is due. This matter was referred for mediation by order dated 19th April 2023, and Honorable Court was pleased to direct that some sum may be deposited before this matter is sent for mediation. So a sum of 3 lakhs rupees was deposited by the petitioner account of the respondent, your lordship. Because last time when this matter came up, some record was missing, your lordship, which had to be come from the lower court. Complete. Full scanned copy, some scanned copy was missing, your lordship. Statement of assets and liabilities, that is the only ground which is taken.
That is
that is one of the grounds.
That is a sufficient ground.
My submission, that is my submission, my lords. I have got judgments on this issue that on merits we can decide, because admittedly, that is an admitted fact on record that he's a doctor working in Shanghai, China, my lords. He's having a salary of 2.50 lakhs back then in 2018.
Beyond record. He's a doctor in China. Was finding is that 1.7 lakh his salary, and the wife is also a doctor, and she's hiding her income.
You see, there was a clear direction in the case of Supreme Court that all the pending applications, also that affidavit is required.
I do not deny it, my lords.
So go and do it. We will ask you to expedite.
I'm saying, my lords, I'm saying after that order also, my lords, there have been many cases. Recently also in 2023, Honorable Apex Court have been pleased to direct the registrars of all the courts that this particular judgment is not being complied with.
So we'll again a
fresh direction has been issued. My point is, my lords, that there is a clear-cut direction that amount is, they have refused to pay the amount. The amount may be paid and the matter may be remanded back, because admittedly there's a divorce case also which is pending. They have submitted their assets and liabilities there also. There they are saying 1.70 thousand, that is on record. 1,70,000.
You are working or you are not working?
I am not working. I am not working.
Being a doctor, you are not working?
No, I was a dental doctor.
Dental doctor is not a doctor.
No, I'm just saying.
A DDS certificate is a document.
I'm not an MBBS. I'm a BDS. That is admitted. That is an admitted fact. I am not working. That is also an admitted fact. Right now, they have from somewhere, my lords. They have produced. They have gone into my personal details. They have got all my bank details as in income tax details, and they have produced. They have annexed those documents.
For the first time in the read court, in this
absolutely, in the read court for the first time.
One document.
But you see, Neha versus Prashant is required to be compliant.
I am not denying
that. So we'll refer it. We'll set aside the order and remit it for that compliance.
I am not denying.
And you will cooperate, I suppose.
Yes.
I'm only praying, my lords, that 24 lakhs and admittedly he's earning. It is not that he's not earning. Since 2013, I have got all the records. If my lords pleases,
we'll pass some order on interim maintenance.
That is only my prayer, my lords.
The relationship is not in dispute.
No, that order
relationship is not in dispute.
No, that is not in dispute. There are other grounds also. If you kindly go through the depositions of the wife and her father, you will find there
is no question of other grounds entertaining.
But if that is the order will go, then it has to be heard afresh by the trial court.
And he's working in China since 2008.
No, evidence only to the extent of assets and liabilities of both of them. And no more. All the evidences which are already on record will be there. There is no question of fresh evidence on that.
I have complied the previous order.
You have filed your affidavit here regarding assets and liability.
No. The previous order was to pay some amount. I have already paid. Yes, that is on the record.
That 3 lakhs, my lords.
So there is stay.
You have drawn that amount?
I have received that.
So there is stay. Already stated.
We'll decide.
Sorry, petition has stated as to how the wife wanted to live separately from the parents. For that was not agreeable to the husband. So she left the house and she started living in the PG. That is supported by the testimony, cross-examination of the PW1 wife.
So there is no reason to live separately, according to you.
As the phrase used by the CRPC, that is without sufficient reasons, she is living separately.
Read the testimony of the applicant.
Yes.
PW1.
Petitioner herself has testified in her examination in chief that she was married to the respondent on 29/11/2011, and after her marriage, she went to her sasural. Just after 15 days, the respondent tortured her physically and mentally, and also left her in her college hostel and never came to meet her. She has further testified that in the month of November 2017, the respondent filed a suit for divorce. And having received the notice, she knocked the door of the Supreme Court of India, but the plea was rejected. In that case, mediation was held, but the respondent denied to keep her with him. She has further testified that the respondent is qualified doctor, his monthly income of rupees 2 to 2.5 lakh per month, apart from some other agriculture income and also the income from the land of his house. Lastly, she has asserted that the respondent had ousted her from his house and has shifted her to her college hostel on 14/12/2011. And since then, she has been living with her parents, who cannot maintain her for a long time. During cross-examination, she has admitted that she is a registered dental practitioner, and he came to know placement of respondent at Shanghai in the year 2015, who had himself disclosed before her that he has monthly income of rupees 3 lakh. She has denied to have any dental practice, but in paragraph 24, she has disclosed that she has monthly expenses of rupees 35,000 approximately, and has denied the suggestion of the respondent that she herself is capable to maintain herself. The learned family court had not discussed the cross-examination of the wife in entirety. Where she has
cross-examination.
Yes, she has contradicted herself. The case of the wife is that in connection with the demand of dowry, she was ousted from the matrimonial house. That is her case.
Yes.
She was compelled to live in the hostel. What she has stated.
Domestic violence case is also filed.
After the divorce case, this maintenance case and domestic violence case was filed. 498 case was never filed.
It is relating to incident of which date? Domestic violence? Because
two cases are pending at the
you went for mediation, both of you, right? Nothing materialized. You are living in Shanghai.
Even in this case,
So you are living in Shanghai. You want to take her?
At that time, I was not living in Shanghai.
That's right. Now you don't want to take her, no?
No, after so many years, that has come in the evidence.
Now when you don't want to take her, you will maintain her. Isn't it?
My case is that she is living separately without any sufficient reason. That is the way.
Therefore, I'm asking you, if you want to take her, you take her.
After so many years, he has denied to the court question. अब जाना चाहिए तो अब नहीं रखेंगे. He has denied examining as witness. Court question में जवाब दिया कि no, I will not take her now.
So when you have given a reply to court question that you will not take her, then you are bound to maintain her. Simple.
If she is living separately without sufficient reason, then I'm not bound to maintain her.
No. Now you say that you don't want to take her.
Hey, whenever she will like to come to me, she will come. Whenever she will like to reside away from me, just she's not. If she is residing separately, it has come in evidence कि मैं hostel में पढ़ने के लिए चली. That is my permanent home. Parents are residing, and she saying कि घर मिला ही नहीं, पता change कर लिया.
Is there any cross-examination on this? कि घर नहीं मिला, पता change कर लिया.
That is the chief. In the chief.
Which is there in the chief. Is there any cross-examination on this? There is no cross-examination on this statement.
Yes.
That you had left the place and then she was not able to find you out. There is no cross-examination. So where will she go to find you out? Was there any effort from your end?
That has come in my evidence.
That you went to her to bring her back?
There is some relevant paragraphs of my testimony.
Yes.
From the deposition of the father of the wife, I want to show that her case is that she was ousted from the matrimonial home in connection with the demand of the dowry. Now she is telling a story that no, after that I went to my hostel, I resided there to pursue my study. Now the father is saying
15 days he left. And you made no effort.
In my chief, it has come differently. She remained there for 5 months. I stayed there for 1 day with her. Marriage was not consummated. She left my house in May 2012.
If we accept all your stories, the fact is that you don't want to live with her anymore.
Yes, that is.
Are you want to maintain her or you don't want to maintain her?
That has come in the evidence.
Then you are bound to maintain her or you don't want to? You are not bound to maintain her legally.
Legally, I am bound to maintain her. But so far as my ground that she is living separately without any reason, she has remained separated for so many years. When I filed a divorce case.
When did you file your divorce case?
In 2017. 17. After divorce case, it was filed. First divorce case was filed, then this maintenance case, then domestic violence case was filed.
Domestic violence case is still pending on the grounds of maintenance itself, Your Worship. And in this divorce case, on the last day, the petitioner has filed their
You were given a chance to file your affidavit of disclosure.
assets of income and liability.
You were given a chance to file your affidavit of disclosure. Why did you file?
Where,
Before the learned court below.
the learned court below. But the learned court below, in the order sheet, at least no observation has come regarding the disclosure of income and assets liabilities, Your Worship. Now, my submission is, my lords, this is one of their grounds. My submission is that at the time when my evidence was taken before the learned court below, that time I was not working. Later on, Your Lordship, I was working, but I was a contractual appointee, which I have got the letter also, Your Lordship, the appointment letter.
Now you respond to his argument that you had willfully left him.
That was the first point that has been
What
raised
is
by
this?
This is, my lords, the reason that he's telling that I was working. This is one of their grounds. I was working. I did not disclose it.
From where do you get this page?
No, this is an appointment letter, Your Lordship.
From where? Is it a part of the record?
No,
It is not a part of
We
the
can't look at it in revision.
It is not a part of the report, my lords.
So therefore, both of you have not disclosed your assets and liabilities.
I admit, my lords, that is an
So
admitted
therefore, so far as quantum is concerned, it has to go. The impugned order has to go and it has to be remitted back. But the point is whether the maintenance case was maintainable or not. Because he says that you have left him without any cogent reason.
Lordship,
This is what. Suppose had you left him with some without any cogent reason, there is no question of remanding it because then the 125 itself will not lie.
I'll satisfy my lords on this, my lords. The petitioners have raised this ground 125. In the instant case, Your Lordship, there is sufficient reason because just after 15 days of marriage has taken place on 29th of November 2011. On 14th December 2011, she has moved out of the house and she has not gone to her parental house. She has gone to the hostel because she was pursuing BDS, Your Lordship, and her BDS was going to finish in March 2012. March 2012, she has completed her BDS. She wanted to pursue her studies. She could not. This is also one of the reasons for quitting, Your Lordship, because the parents. Now, this is not on record, and the parents
Please
of
don't speak anything which is not on record.
no, but And secondly, the petitioner himself, he has said that he refuses twice. This has come. Your Lordship may kindly see page number 31. Running page. During his cross-examination in paragraph 24, the petitioner has admitted that he cannot display any documentary evidence in support of his contention of making payment of any amount to the petitioner in the year 2015-16. He has further admitted that he is a doctor of. She has never tried to restitute his conjugal relation, but in his answer to a court question, the respondent has disclosed that even if the petitioner becomes agreed to live with him, he shall not allow her to live with him in his house.
That is there.
But you also did not make any attempt by filing any petition under restitution of conjugal rights.
That was not never filed by me.
You say that you made some payment in 2015-16.
There is no proof. There is no proof. Just oral evidence has come. That was an arrangement between the wife and other social arrangement. I paid 18,000. There is no proof. There is no document has
What
been
kind of social arrangement was this? He has further testified that in the year 2014, the petitioner lodged a complaint before National Women's Commission, and compromise was done in the year 2003. In the light of said compromise, he started paying a sum of rupees 18,000 per month. There was a compromise?
There was a complaint. There is not on record.
So
This is your statement. This is your statement. This has come up during your cross-examination. It is not in dispute that there was a compromise where you agreed to pay rupees 18,000 per month. Then why did you discontinue? You discontinued thereafter.
If there is discord between the wife and husband.
So that is why we asked you to go and settle. You could have separated also on permanent alimony.
No, the demand is 1 crore. Before the mediation center, she demanded for 1 crore at Ranchi mediation.
She has demanded less.
One client cannot. I don't know. My client will say, I cannot pay
1
so
crore
much.
permanent alimony. And how much is the what's your age?
40 years. Right now, presently she's 40 years.
She is 40 years,
Yes,
right?
Yes.
What is the maintenance fixed?
50,000.
50,000. So 50,000 maintenance. If you calculate it, how many years will it take to complete 1 crore?
17 years.
Sorry.
17 years.
So it's a good bargain. You do not agree?
You know, then the matter.
No, I just.
Instead of remanding back to the London court below, the both parties may be directed to file their respective affidavits before this.
What
affidavits?
affidavit?
It can be decided on merit.
What
The
affidavit?
disclosure of assets and liabilities.
You see, your entire discord will come to an end. Your matrimonial dispute will end. Your this domestic violence will end. Your this case will also end.
Yes.
It can end up in a permanent alimony. But I think you are not well advised. Because as it is, you see, I
acceptable to my client or whether
I don't know,
within
because-
his paying capacity or not. That should have.
You see, something has gone in the
If there is something
proceedings.
reasonable that is acceptable to my client,
I-
otherwise
I do not know.
every husband wants
Your-
peace.
Everybody wants peace in life.
Everybody wants peace in life. So,
Right.
not husband,
Everybody wants peace in life. Professionals need more peace.
Yes, yes.
And advocates are the most peaceful human beings on earth because they know what are the nuances of.
After knowing all these things,
So therefore, it is you who has to advise your client.